Good afternoon, everyone. With Dean Ma'am's permission and our guest speaker's permission, should we start with the session?
Yes, please go ahead.
Greetings to one and all present here. I hope you're all keeping well and keeping safe. I, Saharsh Panjwani, on behalf of the entire team of the VIPS Law Blog, the Law Blog of the Vivekananda School of Law and Legal Studies, VIPS, welcomes you to our introductory session on legal research and writing. Writing is the heart of legal practice. The reason being that legal writing is the central medium with which a lawyer communicates his or her work. The most brilliant minds will have a difficult time in this profession if their writing skills are not at par with their ability to effectively read, research, and analyze the law. Similar to many of our attendees here, before coming to law school, I assumed that the key to being a good lawyer is simply being a good orator. However, I have discovered that legal writing is the real bread and butter of a lawyer. With this being the case, resources on skill building, specifically with respect to legal writing, remain scarce and only inside the confines of most Indian law schools. With the object of easing this journey for law students and professionals, the VIPS Law Blog team has organized this session. Uh, before going Before going ahead, we have a few small announcements. First and foremost, we request all the attendees to maintain utmost decorum during the session. And secondly, if you could save all your questions till the end or just put them in the chat box, as we'll have a short Q&A session towards the end of the session after our guest speaker's address. Now, I have the distinct pleasure of inviting Professor Dr. Rashmi Salpekar, Dean VSLLS VIPS, to give the welcome address. Ma'am holds a PhD in international law, for which she received a fellowship from the Indian Council of Social Science Research from the ISSR New Delhi. Ma'am has pursued her master's in human rights and duties and an MA in sociology. Ma'am, we'd be very honored if you could give the welcome address.
Yes, thank you so much, Saharsh. Very good afternoon to you all. And I'm extremely happy that this particular theme has been selected by VIPS Law Block team. Under the guidance of Ms. Ravneet, Ms. Samriti, and Dr. Sushila, a group of students, they have come forward to start VIPS Law Blog. I would like to welcome Mr. Tariq Khan for this particular webinar. And as Saharsh also said, that yes, legal writing is in fact, there is no other key for legal profession unless you are not aware about legal writing and the skills of legal writing. As legal writing is very, very important, in addition to this, writing in crisp manner and very, very specific, it is also very, very important. It's not only that we are required to fill the pages after pages, but we are required to understand that how logically we are required to put forward our arguments, how to write. In this context, writing blog is also very necessary, because in blog, it is not something that we are required to have a lot of words, means we are not having liberty to explain it in an elaborative way. But yes, explanation is required. So in a crisp manner, very specifically, we are required to write the blogs. So therefore, when students last year, they came to me that we would like to start with VIPS Law Blog. So Mr. Khan, I was really, wondering that whether I should give them permission or not. Then few faculty members, they also came to me. They said that, yes, we will take care of it. You please allow. And since that day, I have seen this particular group. They are really working very hard for this VIPS Law Blog. And it's not only that they are, increasing their network to get more and more blogs, but in fact, they are also dealing with these kind of themes, like how to write blog and what kind of themes must be there on blogs. So therefore, in totality, they are thinking. So therefore, this is, I would say that this is what is my gain, which I was really expecting when I gave them this permission that, yes, you can start with VIPS Law Blog. So with this, I would like to welcome once again on behalf of the management of VIPS, as also our chairperson, Professor R. Venkatarao, Professor TV Subbarao, and on behalf of all dear students and faculty members, I wanted to welcome you to this webinar. Over to you. Thanks.
Thank you so much, Dean ma'am. I couldn't have imagined a better note to start this session on. I now have the immense honor and pleasure to introduce our guest speaker for the day, Mr. Tariq Khan. Sir is currently working as a registrar of the International Arbitration and Mediation Center, Hyderabad, and is a former partner of Advani Law. He has significant experience in domestic and international arbitrations, commercial disputes, insolvency and bankruptcy cases, writs, MSME disputes, and arbitration-related litigation. He has been listed as in the Forbes Legal Power List of 2020-21 as one of the top individual lawyers below 10 years of practice, and was the youngest lawyer listed in the Business World Legal 40 under 40 in 2020. He has been recognized as an arbitration expert by SEC Online and has more than 50 publications to his credit. Although this is just the tip of the iceberg, we hope this serves as a fruitful introduction for our guest speakers. With this, I respectfully invite our esteemed guest speaker to grace us with his insights and his address. Over to you, sir.
Thank you, Saraj, for such a lovely introduction. Thank you, Professor Rashmi, for inviting me. And VIPS blog, I think I've also written something for your first edition, and I was very privileged. And I think the theme that I chose was cryptocurrency. Generally, I'm not a tax expert, and that's one subject I shy away from writing. But today's discussion is all about writing. And I mean, I would like to first mention that whenever you have to write something on a subject that you have, some expertise on, or you have some experience on, when you have that grip on a particular subject, it's much, much easier to write, whether you are drafting, whether you are writing an article or a blog, or for a journal, you're writing a paper. But when you choose a subject or a topic which is not your area of practice, it gets really difficult. For instance, I give you the example of the article that I wrote for your journal. It was pretty tough because I'm not somebody who's a tax expert. So you have to read quite a lot. But anyway, today's discussion is quite interesting, and I was very much happy with the topic, the theme that you all have chosen, because I'm not talking about arbitration. Usually arbitration and mediation and ADR is what I talk about, commercial law. But this is an interesting topic, very close to my heart. And before I begin with, I would just like to tell you how I got into writing. For somebody who, I was never somebody who was interested in writing or reading. And English was not a language I was familiar with until I came up, in my second year or third year of law school. But it just so happened that I realized the importance of legal writing pretty early in my law school when we started drafting memorials for my moot courts, because I think that's one thing we all love to do, because mooters are treated like gods in law school. And if you're a good mooter, no matter how you behave, people really like you, and people are very fond of you, because mooting is pretty popular in all law schools. The first thing that I realized was that it's very important to have command over the language, and that's when I started reading Krishna Iyer. So Justice Krishna Iyer has been my role model since day one when it comes to writing. Even though his language was very flowery, and he used to coin certain words in his judgments, but in my moot courts, I started quoting his judgments as it is, and many of them I know still. And I recollect when I heard the news of sudden demise of centenarian Justice Krishna Iyer, I never got an opportunity to actually meet him. It was more like a case of Eklavya, who never really got a chance to meet his guru, but he used to just read from his judgments. There's a lot of jurisprudence from his vast knowledge of law as well as the legal lexicon. He used to coin words. He used to make some phraseology. The use of terminology by him in his judgments was very impressive, and I used to be very, very inspired. So it just so happened that when I'll give you one incident. When I saw the news that he passed away, I was in an arbitration proceedings. Though I was not a counsel, I was only an administrative assistant, and my role was very limited. Because I had read all his judgments, most of them, I was able to pen down an article to give him a tribute to Justice Iyer. And then I wrote that article on my mobile phone. I know it sounds very absurd, but because I had that knowledge of his judgments and I knew which judgment said what, So I was able to put it, structure it in my mind immediately and come up with an article, and then I sent it to Bar and Bench, and then it was published the next day. The reason why I'm telling you this incident is because when something is there in your mind, when ideas come to your mind, they come in the form of a draft. And once you start acting on it, it starts taking a proper shape. But the catch is, when that idea comes to your mind, you have to immediately pen it down. Many times I've seen people with great ideas, with excellent ideas and topics to write on, but that never really materializes. I've never seen them acting on it. They just talk and then they forget about it. As a result, maybe a very interesting read or a piece that could have been penned down or could have been published in a reputed journal, that idea is lost. When you talk about writing, legal writing is extremely important. Saharsh has very rightly pointed that you see the credibility of a lawyer, the skill, because you can't really go and argue in a court of law in every city and every state or internationally. Even if you are an amazing lawyer, you have those, the gift of gab, the advocacy skills that are required. But when you write, the words remain in public arena. You know, people can read internationally. Your reach increases extensively. And I will say it for myself that many of my young friends who know me today, and when they invite me, it's only perhaps because of my writings that they have been able to read and they have been able to form an opinion. And maybe some of them, they liked it, though I don't personally like most of my articles, but some of you may have read the articles that I have written. And I think the reach, your audience increases, you are acknowledged, people really get to know about you, your views on the subject. So writing is extremely important in growing you as a person as well as a professional. So I highly recommend all of you to start writing if you do not already write. Now, many questions come to one's mind when you talk about writing. They have the knowledge, they have the expertise, but they don't know how to write, how to get it published. Too many questions. So, but we will be taking questions also because I've been interacting with a lot of students who had various doubts about writing. Now, first, what I've done is I've structured today's discussion in a very crisp manner. I'll be giving you some bullet points that you can note. And what we can do is we can elaborate on it, and then whatever questions, I'll try to answer a lot of questions in this discussion today. And in the last 15-20 minutes, we can perhaps take certain questions. If any one of you has any question, you can also ask me during the presentation. But I think I will be able to cover most of it in my speech today. The first point which I would like to highlight is, let's go to step one. Whenever I write it for someone. So I'm writing this article to somebody, to a reader, to a prospective reader. Now, in my mind, I need to have a clear picture as to who these people are who are going to read my article. Sometimes I have seen people writing articles just because they want to write an article and they want to post it on their LinkedIn or any social media platform. At least with me, that's never the idea. I write an article when I have to, and when I feel the need that there is a dearth of literature on a particular topic, and I think I should fill that gap. That void has to be filled. Like if you look at my recent articles, I've chosen topics like confidentiality, arbitral immunity, blue pencil doctrine, dissenting opinions. These are my last 4 articles. I don't think there is any literature or a lot of literature on these topics, and that's why I wanted to contribute. Because if you write something on a topic on which already a lot has been written, I don't think anybody is going to publish your piece, to be honest. And even if it is published, I don't think many people will be reading it. So you have to be very careful about it, but we'll come to that. So the first thing that you have to do is remember your audience, your target audience, whom you want to write it for. What are you targeting? Like, for instance, if you're writing for law students, you have to choose something on those lines. And if you're writing for targeting particular clients, if you're in a law firm, you have to see what is the area of practice you are entering into, and what kind of clients you want to target. If you want to target, for instance, construction industry, So you need to write on damages, quantum, delays. If you want to target somebody who's doing arbitration, you perhaps may write an article which deals with arbitration clauses or how to resist arbitration claims. These are the topics you can identify so that anybody who's a stakeholder or who is a prospective client can read your views and benefit from it. And this is how you can connect to them. But when you are talking about your audience, you need to remember that every word you are going to write in your article, it should be tailored and tailored to the needs of the reader. It can't be tailored according to you because you are not the one who's going to read it. You're just the one who's writing it. Article always has to be written, or any drafting for that matter. I'm just going to give you the tips of writing. I'm not going to specify whether I'm talking about an article. So if I say article, it also applies to drafting in the court or in the claims or in the petitions which you are doing, or even if you are making a memorandum for your moot court or for your client. So anything you are writing, every word should be tailored as per the needs of the reader. If it's a judge, you have to be very careful what kind of language you have to use, because it has to be persuasive as well as you have to advocate a side. It can't be very neutral and something against you cannot be put in there. Now what you do is you can create a person. When I write, I create a fictitious person in my mind. And in my head, I imagine, okay, there is this person I'm going to target. For instance, I'm targeting a lawyer. So I will think, okay, this lawyer may be having a lot of matters in court, maybe a busy family life also. And this person really wants to be updated and wants to know what are the matters, what is the latest update on arbitration. He's an arbitration lawyer or she's an arbitration lawyer. But to be updated, this person can't really give the kind of time which is required to read a judgment or to read a lot of developments which are happening across the country. So what I started doing, I started writing, you may have seen some of my articles on Bar and Bench, which are specifically the compilation of cases of 6 months or 1 year, only dealing with those cases which are on arbitration. So that is quite helpful for a lot of lawyers. And I think that's one of my pieces which is read extensively across the country as well as internationally. Because I was able to imagine that as a lawyer, what is it that I want to read? I want to read the articles which are going to help me in my day-to-day job and keep me updated without wasting a lot of my time. Crisp. So that's the idea you have to apply whenever you want to write. The other thing is that your piece has to be, the language. Once you know you are writing it for someone, your language will automatically be more and more appropriate, and it will become reader friendly because you have that in mind that I'm writing it for a person to read. Now, if you are, for instance, if you are drafting a brief for a judge to read or an application, it has to be persuasive because you are convincing the judge, because the judge will be reading it in his chamber and getting to know your case through your perspective. So a lot depends on that. Maybe judge is able to make some mind after reading your brief. Similarly, if you're making an opinion, legal opinion for your client, you have to very properly analyze the issues, identify them, and state the position of law on that. And accordingly, you have to recommend a proper course of action which is to be followed. So the bottom line is that the first thing is to identify your audience and accordingly write as per their needs and as per not what you feel should be right. Now, the other thing is that second advice which I will give you is that you need to keep a list of ideas handy with you. If you really want to write regularly or frequently, what I do personally is I have a group on WhatsApp in which there is nobody except me. And I call it to-do list. And you can also do it. What you can do is you can add one person in a group and then remove that person. So then it becomes just you. And I call it to-do list. Now in that list, what happens is, for instance, today I am listening to a webinar or a conference, some expert is speaking, or probably I'm reading something. And maybe he or she has said something very catchy and interesting and pointed out any lacuna in law. What I will do is I will immediately note it down in my to-do list, that topic, and I will leave it there. Similarly, I keep getting ideas in my mind while discussing with clients sometime when they raise an issue, we are facing this issue. For instance, a few days ago, an issue came up whether GST is payable on the fee of the arbitrator. And I found it to be an interesting issue, because I was like, maybe many people do not know what the position of law is on this. So, these can be the ideas which come to you, and you keep writing in your to-do list that, look, I am going to keep a list of ideas. So you jot it down in your notebook, you can write it in your WhatsApp, so that whenever you have to write, at least you have a place to start. Because most of the times people are like wondering, okay, what do I write on? They will sit with a pen and a paper, or they'll sit with a laptop, but they don't know what to write on. So I think that that can be very, very useful if you have a list of topics handy. The third thing is you have to eliminate distractions. Now, what distractions I'm talking about? So as a matter of exercise, what you can do today is that you can go to your Instagram and check your activity area. It will show you how much time you're spending on your Instagram. I was surprised to see that I'm spending 30 to 40 minutes on my Instagram every day. So the idea is that when you are planning to write or draft anything in legal, any kind of legal writing, I think it's extremely pertinent that you switch off your TV, switch off your mobile, or put it on airplane mode. Your social media has to be muted, because any article writing or any kind of drafting requires full focus. Undivided attention is what is required. And I personally have seen the best of my pieces or drafting came up only when I had no distraction. Even though I used to convince myself that I can multitask, etc. But I strongly feel that you should never be having this kind of confusion. Do not give divided attention to your article or to your writing. Legal writing requires complete undivided attention. And that's exactly why I write most of my articles late at night when there are no distraction. I'm not getting WhatsApp notifications or no calls. The other advice that I'll give you is research, because today's topic is also about research. So I'll give you in brief certain suggestions about research. Now, this brings to a very old interaction with late Mr. Ram Jethmalani, wherein I remember he telling me that, today's generation is all about Control F, Manupatra, SCC Online, etc. Though these are excellent platforms, you should use SCC Online, but you should also use the books, the commentaries. He said when we were there and the search, we would manually those judgments we used to manually read. That's how we used to develop the art of reading. But today, I don't know how many of you can ask yourself this question. How many of you actually read these commentaries and these journals which have the cases, etc. Those books which come digest, nobody reads it. So that's, I think, one thing very, very important thing which you keep in mind is that you should start going to library, open your books, research not just on online platforms, also start reading commentaries. It's quite easy only if you know how to use it. So I think that's my first advice. The other thing is that do not forget about the hierarchy of the sources you are relying on. Like if you are going to court and if you're drafting a petition or a memorial for a moot court, you need to know whether you can cite a judgment of Supreme Court or you should be citing a judgment of High Court. Obviously, Supreme Court judgments are always preferred. The other thing that you have to keep in mind is that you have to see whether this judgment has been overruled or not. That's something you always have to cross-check, because it is quite embarrassing if in your article or if in your brief, you're relying on a judgment which has been overruled. One advice I will give you, that you always rely on the latest judgments, because you don't know what is the position of law. Do not rely on judgments which were in 1961 or 71 and then you call it a recent judgment. So that's my suggestion. So these are few things, and you have to be very careful with the keywords. The key to a good research is a good keyword. You need to start framing in your mind what can be the keyword. And you need to start making synonyms in your mind. Okay, if I'm looking for fraud, what can be other synonym for it? So look at it like that. For instance, I was required to research on a point like there was an award which was a vague award. And I wanted to show any award which is vague cannot be enforced. Now, when I was looking for this on search engines, it was not coming. So I started changing. I started looking for different keywords like award has to be definite, or award cannot be ambiguous, The awards need to be definite. Arbitrator's decision cannot be vague. Things like that. And then I did find something around this area. So all I'm saying is that you need to have that kind of alternatives ready in your mind if you don't find the exact keyword that you are looking for. Now, I have been emphasizing quite a lot recently on the topic of the title that you are choosing for your article. If you're writing any article or a research paper, I personally feel it's extremely relevant. It's extremely important. Now, imagine if you see a regular update, uh, arbitration update as a title, or insolvency news. I don't think you'll be opening it. I mean, at least I will not open it unless my mouse really slips on that and by mistake I open it. Or maybe if I get it from a credible author, somebody I know writes pretty well, if he or she is sending me, then I will definitely open it. But what I'm trying to tell you is that your article title has to be extremely catchy. Now, do not make it too fancy that the reader may not even understand what you're trying to say, because the reader will not have that kind of patience to first understand your title. The title should be such that it can grab the attention of any reader or anybody who sees it at first. Only then you will be able to convince your reader to open it. So opening the article is a challenge, because if you see SCC, Bar and Bench, Mondac, there are so many articles being published every day. Nobody has the time to read it. But only if your article is unique and with the title it looks different, then a person will be able to enter it. So once the person opens it, that is when you have actually won, and you have actually, your hard work has actually been recognized. Because unless somebody opens it, no matter how good the quality of your article is, it's not been able to help anybody. Apart from the title, there is one more thing which you have to keep in mind. You have to keep a good image. Now, usually, I'm somebody who also publishes my own picture. So please don't do that. What you can do is you can perhaps take a nice picture which is relevant to the theme of your article and which explains what people can expect in that article. And I think that visual can play a very important role. It can influence the choice of a reader and compel them to read your article. So choosing a good image, is quite important, and it can show that, it's quite informative. Now, how do you take care of other things? The other things are that when you're starting your article, sometimes you can choose your article also as a question, like whether XYZ can be done or not. Some interesting question which has an answer, and you are going to provide that answer in your article. But remember that when you are doing it, do not give that answer just in the first paragraph, because otherwise nobody's going to read the full article. And what I have seen is that people generally do not read the full article till the end. So it's a task to make some reader read your full article to create that kind of excitement. Your writing should be engaging, arresting, informative, and succinct. The idea is somebody who reads the first few lines should be compelled to read the full thing. Because, if you can't generate that kind of excitement or interest in the first few lines, they are very crucial, the first paragraph, then I'm afraid that, readers may not be interested to really go through the whole piece. Another thing you have to keep in mind is that citing is very important. Do not keep it plagiarized. Do not cite somebody, just rely on somebody else's work without adequately giving citation. The source has to be provided always, because it is better to safe than sorry. The most important part of an article is structuring your article or your writing, even if it's a drafting or it's a statement of claim. Structuring is the most important part of any writing. Now, why do I say it's important? Because if you do not organize it, the reader will not be in a position to understand it. Whether you're writing a book, or you're writing an article, or a memorial, or drafting a brief, if your structure is not proper, in a planned manner, in a continued manner, then nobody will really be able to understand. And the worst part is that you will not be there sitting on their head to explain them what it is. The person has to understand it. The reader will just have a look at it. It should be so easy to understand that a person can just simply understand what it talks about. Now, Introduce your subject in an introductory paragraph. That's the first aim. That first paragraph should be the introduction of what I'm going to talk about. Thereafter, you break certain the articles in various headings. Now, what I do personally as a matter of practice is that when I have an article, I will first make an index, a table of contents. You know how my article should look like. Okay, there'll be an introduction, then there'll be this problem, then I will address these issues, then I will address the latest judgments, then I will address the international position, and then there'll be a conclusion. So unless you have a structure in mind, you really cannot work on an article. You have to first make a summary, or you can just, make some headings that you can fill later. This will help in structuring your article, of course. Now, you need to limit each paragraph to one topic and sum up your message with a concluding sentence in that particular paragraph. So the idea is to keep short sentences and short paragraphs, not the long ones. That's a big, big turnoff. Larger fonts are better than smaller fonts, because nowadays what is happening is people are reading articles in their phone. If it's possible, you always go for a larger font. Idea is to promote clarity and avoid the legalese. The fancy language you have to ditch. You have to keep it super simple so that any stakeholder, any regular person who's not a lawyer also can understand what you're trying to say. So simplicity is very, very important. Another very important point is that you have to be concise. You have to be brief. Why? Because every word you are writing in your article should contribute to your message and should not be irrelevant. I can give you a reference or example of various sentences that we use, which are running into 20 words. But I think if you can use 10 words to communicate the same message, then avoid using 20 words for that. So irrelevant, redundant, you need to eliminate all of those words which are not required to communicate your message just because you want to make it flowery and you want to add, fancy language. That is not something you should encourage. Another thing is that, if you want to make an impact or if you want to clarify the meaning of the sentence, then you omit all these unnecessary words. And the reader's attention span is generally very, very short. So one of the best things that you can do as a writer is to keep your article direct and concise, because nobody will have the patience to really go through something which is unnecessary and irrelevant. For that, I will recommend that you write in bullet points. Now, writing in bullet points is useful for two reasons. One, it organizes your thoughts in a very crisp manner and you can complete the article pretty faster. The other thing is when search query, the search engines, the algorithm is that these bullet points in an article, they get, priority by the algorithm when you are searching a keyword. So your article will appear first over other articles which have been written in a story format, the narrative. So I would strongly recommend you to write in bullet points. So this way your target audience will be, there are likely higher chances that, they will be able to read it and your target audience will get the message that you want to give them. Another thing which I personally exercise is that, you have to use action words. Now, what are action words? Sometimes when you write, the claimant was not honest. Now, if you're writing it like that in legal drafting, I think this is the weaker version of drafting, I would say. Instead, I would say the claimant lied. Similarly, if somebody has to say that the expert witness quickly came into the room, I think the better way of saying it is in drafting, in writing, is that the expert bolted into the courtroom. The judge was angry. It can be better that the judge was enraged. So you have to use action words to make it more powerful and the impact is better on person who's reading it. That impact is very important. You can communicate more effectively. Another mistake that I think people commit while they're writing articles is that they use passive voice. Now you have to tell the reader who is doing that act and you have to clarify your message. Instead of saying a crime was committed, you have to say the defendant committed the crime. So, in putting it in past tense really sometimes does not clarify who did it. A petition was not filed. Instead, say the claimant's counsel did not file the petition. So avoid using passive voice. I think that will make a huge difference. Before I run out of my time, I'll be quick. I know I'm just going on and on. So another very important aspect of writing an article is editing ruthlessly. You have to be an excellent editor. Spelling, punctuation, grammar, grammatical errors should not be there in a document submitted either to the court or to the client or to the opposing counsel or to a journal. Most of them will get rejected because of this reason. And if you are using it in a court of law without editing, it will undermine your credibility as a legal professional. And even judge will form an opinion about you. Okay, this is how he draft. This is the quality of this lawyer. So I think editing is extremely important. Now, when to edit? Most of you edit while you are writing, while you are drafting. I would strongly advise you not to do that. I think first you draft without editing, prepare a first draft. And once that is done, then you start editing properly in a proper manner, proofread it. Because what happens is when you are writing and editing at the same time, it will slow you down to a great extent. And the other issue is by the end, you will be so confident about it and so bored of editing that you would not want to proofread the whole thing again. So I strongly advise you to edit it only once the thing is complete. And you have to be brief. I was not able to focus enough on the attribute, on the quality of being brief. The skill of a lawyer is not just dependent on somebody who has the knowledge, but somebody who is able to effectively, whether in writing or orally, communicate in a very crisp manner because the time is limited. You have to be extremely crisp and concise while you are communicating your point to hit the right chord. There's a very interesting saying that, Dr. Johnson was so right when he apologized to Boswell for writing a long letter because he said he did not have the time to write a short one. Now, what this means is that writing a long letter is easy, but to be brief and to be crisp, it's difficult. All of you must have witnessed that when we are writing a moot court memorial and there is a page limit of 1 page, and we don't know how to put 35 pages in a page. So that is the beauty about being crisp and being concise. So anybody who can write in a concise manner, I think that shows your expertise in a subject, because brevity is not necessary only because it is the soul of a wit, but also because it is important to strike the right chord in a judge. If you're writing all irrelevant stuff, the relevant part will get lost. So be crisp. Any message that you want to give to the readers, to the judge, you have to be extremely precise and remember the value and importance of brevity in any drafting. One thing which we all cannot ignore is that the judiciary is the strongest bastion of the English language in India because most of the legal lexicon comes from there. So start reading quite a lot so that you are able to draft in a proper fashion. Legal drafting will improve if you read more and more judgments and give attention to its nuances, and that will be very useful for you as a writer. Now, moving towards the end, I want to tell you that when a person writes briefly, so brevity will show the extensive knowledge and extensive writing of a reader. How much he reads. Only then he can put it in a proper manner. He will be able to put his point. When someone is in the grip of the subject and able to communicate its essence effectively and engagingly. But that will happen only if you have read that much, frankly. So reading is more important to, really write well. So first you have to start get into the habit of reading regularly if you want to write. So the language of law that you are using in the legal writing must not be foreign to the people, to the readers who are going to use it or who are going to implement it. So get it right and keep it tight. The words have to be simple, plain, and if you can use plain English, please do, because that's what is required. And the goal is always to write a piece where none of the sentence should be repeated 2 times. A lot of people repeat again and again. I think that should be avoided. None of the sentences on the drafting should be repeated 2 times. That's irrelevant. Increasing the words is irrelevant. And like that it's a profession which is not just of lawyers, it's a profession of literature also. A lot of literature keeps evolving, and law is an art as well as a craft. We know it's a profession where you learn art and craft also. So I think these are the things which I would like to point out. Lastly, don't use words like which are too strong, like nevertheless, nonetheless, the aforementioned. Avoid all of this from drafting. Keep it extremely crisp, and always remember to connect it like a story, so that a person who's reading it should feel that he's or she is reading a story. Don't forget to connect to sentences from words like however or additionally, further, moreover. Use these words often to connect sentences. It should not look like, okay, I was reading one part, now this is completely isolated. It should all be in a proper flow, connected in a continuation. I think that's what will improve your writing skills quite a lot. I think I've said enough. Thank you very much for your patience. And now if you have any questions, I'll be happy to answer.
Right. Firstly, thank you so much, Tariq sir, for imparting your wisdom to all the attendees here. We have over 140 attendees who attended, and this includes not just law students, young professionals. We have people who are litigators, people who work in firms, and even people who haven't joined law school. So it's quite a large demographic that we have. About not just your experience with writing, but also taking us through a few pieces that you've written. So, first question we have is from Kashish. Can you go ahead?
Oh, right. Hello, sir. Thank you so much. My question is, as you started the session, you said that English is something that you had to acquaint yourself with after joining law school. And perhaps it's the aftershocks of being colonized, but English is something that is valued a lot in our profession and in law school. So what are some things that you learned in your journey of acquainting yourself with the language, or relearning or unlearning things when it comes to the English language?
Okay, thank you, Kashish, for this question. It's a very relevant question for any writing in our profession. So unfortunately, a lot of emphasis is given to the language. I think more than language, content matters. According to me personally, I've spoken on various occasions that language is not the measure of one's competency or talent. Maybe there is a person who speaks fluent English, but content is zero. So without the content and without the reading, you will never be able to communicate yourself. And I personally learned English, and I think whoever wants to understand English or speak English frequently, read as much as you can. When you read those kind of judgments, you automatically start speaking the law. So sometimes, words come to my mind randomly when I'm writing, because maybe I have read it in some judgment and it comes to me. So the more you read, the more you can write, the more you can speak. You will never run short of content if you have the ability to read and if you have read extensively. I have met some people who had impeccable English, flawless, but when I asked them to speak, and you can all do this test. I mean, I would strongly, advise you all to consider taking this challenge. Stand in front of the mirror, see what you all love the most, maybe fashion, maybe social media, Instagram, anything. And if you can speak on that topic for 2 minutes, you will really know manner, matter, method. What is in there? So fluent. I've seen people after 10 seconds, they were blank. They did not know what to say. So I think language is not everything, but it is very important in our profession. I think lawyers, must really be able to express and communicate in a proper manner. And content is what they should focus on, and automatically your language will improve.
Right. Now I'll request anyone and everyone who has questions to post them in the chat box. In the meantime, we received a few questions from the registration form that we floated. I think we can ask those first. So the first question is, sir, as you mentioned even in your address, that try to write on laws or on subject areas which don't have a lot of literature ongoing. You gave the example of crypto. So this person asks, how do they start their research on something that doesn't have a lot of jurisprudence or is in its very nascent stage? Could you give them some advice for this?
Okay, so for instance, when this announcement was made last week or 2 weeks ago about regulating crypto, so obviously, there may not be a lot of content on a particular subject, but then that's when your viewpoint comes into play. What is your viewpoint? What is the international practice? How other jurisdictions have dealt with such situation, or how generally tax, regime should be regulated? Whether how easy it is to regulate. Viewpoint of investors. You can see various things are there. You can just see how beneficial it can be and how the interest of the state can be protected. If you can't directly find something on crypto, you look at other aspects like why it is important to tax, what should be the mechanism to tax, how investors will react to this, how it will impact ease of doing business, what are the downside of not regulating it, whether regulating it means that you're also legalizing it. All of these comparisons you can do. What is the international perspective, how different developed countries have dealt with it, give examples of countries which have banned it. Then accordingly, after reading so much, you can give your own viewpoint, and in my view, this is what should happen. So this is how you are, in one single article. And okay, one more question I forgot to address in my presentation. What should be the length of an article? If it's an online article, remember it should never exceed 2,000 words. Never. And most of the, journals or probably blogs will not even publish your article if it's too long. They have this condition. So always remember that also. Yeah, sorry.
Right. So now I'll start to read the questions from the chat box. We've got quite a few questions. I'll try and skip over questions that you've already covered in your address so that we don't double dip. From Meghna Malhotra, the question is that how can we make an interpretation article interesting like a case analysis for that matter, since it's all about the point of law, which is the same everywhere over the internet or on research journals?
So making an article interesting, it's on you, frankly. If you make it personal, okay. For instance, I'll tell you one article I read. There was too much written. I had also myself written on Vodafone. It was published in Monday. Now I read one foreign author who had very beautifully, because I had read so many articles, but one article that he wrote to make it interesting. He started with a very interesting quotation, and I liked it quite a lot. It was very apt. And then he started by saying, imagine you invest in a country, XYZ amount, and then you are asked to pay this much tax, and which is unreasonable. And then you end up fighting in court, and the Supreme Court of that country rules in your favor. And then you are pretty happy with that after so many years, finally the truth has prevailed. And I'm not supposed to pay anything. And all of a sudden, the ministry, the finance minister, makes an announcement that we will retrospectively tax entities. And again, the demand is restored. So, he made it very interesting and very sarcastic at the same time. So it completely depends on how you present it. And I think making something interesting is how you link one field of law with the other. If you're writing something on interpretation of statutes, you can perhaps give reference of penal statute, taxing statutes. You don't have to limit yourself to one kind of one field of the law. So the beauty about law is that everything can be linked with each other. So I think that should be the strategy if you want to make it interesting. And language obviously will play an important role, how you structure it.
Right, so thank you for that. I think we have a lot of questions on precedents, how to read judgments. I think let's perhaps combine them and put them in under one umbrella, because if we perhaps go over each and every question, we'll be here all day. I think the broader theme that's coming up is A, how do students approach reading judgments, and B, also which precedents should they see and look out at. So typically, as one of the examples that you gave in your address was, they can avoid really, really old judgments, 80, 90-year old judgments. So how do they start approaching that, and what time period should they first try to read judgments for?
So see, a good example is if you're planning to, so I strongly advise everybody to read judgments. irrespective of whether you want to write or not. Forget that part. But you have to read the judgments, because if you want to be updated with the law, the only way is to read judgments. Now, nowadays, it is quite simpler. For instance, if any one of you is an arbitration enthusiast, merely by reading one article that I have written on Bar and Bench, you can get access to what happened in 1 year in arbitration. I have summed up all judgments for you. You just have to read it. And if you find any judgment very interesting, you open it and read the full text. Now, let me give you an example of one judgment, for instance, on seat and venue, which can be Justice Nariman's judgment on Hindustan Construction Company. There's a reference, there is Associate Builders, there's Sangyong Engineering, which talks about 34. So any one of Vidya Drolia, let's talk about Vidya Drolia judgment, which talks about arbitrability of disputes. Now, if you want to write an article on arbitrability, you don't have to go to Booz Allen Hamilton and Iyer Swamy and other judgments, Amit Balchan Shah. You just have to read this one judgment. This judgment is running into so many pages that they're all the law of preceding years has been covered by the judge himself or herself. So when the judge is doing all the homework for you, you just have to read the latest judgment. Most of the times, they cover the position of law since the beginning, and they deal with all judgments which are existing and which is the correct position of law and which isn't. That's one way of doing it. The other way of doing it is you can look at any article which has been written by an expert or by any authority in the field. They cover the position of law on that particular point. But it cannot be that there is an important judgment and you read it merely because it is old. Maybe that is the judgment which has laid down the law on the point. If I talk about seat and venue, Balco judgment is an old judgment, but it is relied in every matter. So I cannot say that don't look at old judgment. There cannot be a time frame. Maybe a judgment of 1920 is relevant. If you look at damages, Fateh Chand is still a very important judgment. It's an old judgment. And at the same time, Dwarka Das is an important judgment. Kailash Nath is an important judgment, which is as recent as 2015 or 16. So idea is to read, and that's why I say read the books. If you are reading on damages, just open the chapter of damages in a good commentary like Mullah or Chitti on contracts. You will see everything which is there. The judgment which is relevant, they have covered it extensively. And that's why I encourage people to read books so that a lot of their time is safe. Yeah, so that's my suggestion.
Right, thank you, sir. So another question that's, again, a few similar questions have come up about sources that people should rely on while writing blogs or papers. Is that how much should they rely on traditional sources like judgments, bare acts, commentaries, and then how much should they rely on already published articles on, let's say, Bar and Bench, Live Law, and so on? So is there some optimum way that they should balance them or rely or skew towards one or the other?
Okay, so that's an interesting question. I'll give you an example of an article that I wrote. I'll give you two examples, actually. So I wrote on dissenting opinions, and I didn't see many articles written on that. Now I have to first talk about the law. What is the law on the point? Whether there is anything existing or not. So for the law, you have to look at the Bare Act. Whether the Bare Act has any provision which deals with it or not. If it does, you have to say that section so-and-so covers this and says so-and-so. You cannot skip that part. That is the most important part. If it doesn't talk about it, then you have to say the Act talks about this, but does not talk about dissenting opinions. It merely talks about the majority awards, majority opinion. So therefore, then you will say that there is nothing in the Act which covers this. You have to start from there. That what is the position of the law in the country or in the legislation. Now you will start talking about your own opinion and how courts in India have interpreted it. There are many things in India, for instance, which are not there in the law, but the courts interpret it from time to time. Then you will start from the beginning. That for the first time, this question came up in so-and-so judgment where the court was, gave its opinion on so-and-so topic. Thereafter, another court gave a contrary view. So you are discussing the law. There has to be a discussion. You can't just miss out on those judgments which have taken a contrary view. So you have to do some research. You have to find out and identify and what sources should be cited. See, if you are quoting an author, you can. if you are taking something from someone, so if you are quoting an expert like Gary Bond in arbitration, you please cite, or you please say, even if you're not giving the footnotes or endnotes, you can still say in the article itself that according to Gary Bond in so and so article, he says so. So at least in articles, one good thing is that unlike books and research papers where you have to follow a proper citation method, like, Blue Book format may be there, or Scholar may be there. In articles, if you're writing for bar and bench, live law, as such, there is no formula. There is no format of citing. You can be very casual in that approach. You don't have to really worry about it because most of them are viewpoint. Unless you are giving a judgment, they provide link. Now the new trend is when you're citing a judgment, it is hyperlink. You can click on it and open the judgment. But if it's about citing, I think the position of law has to be cited. For instance, if you are writing an article on arbitrability of fraud, you cannot skip judgments which are fundamental, which are extremely important where the law was laid down. You cannot skip Booz Allen Hamilton. You can't skip Amit Lalchan, Ayyar Swamy. These are important judgments on the point. So all those judgments which are relevant have to be there. That's what you have to cite necessarily. The other thing you have to do is you have to deal with what law says on that, whether there has been any amendment to that or not, whether Law Commission or report did mention about it or not, that particular topic, and what is the position. You can quote some international experts who have said something. I think that will add credibility. But apart from that, I don't think you need to really quote on anything. You can give your own viewpoint. When I write my own view, what I think it should be and what it is currently and what are the problems and what is the solution. So your article should identify the problem and give a solution, rather than just talking about problems, etc. So I think that's how you contribute.
Right. Thank you so much, sir. And I think even the piece you allowed us to publish of yours also was hyperlinked for the most part. So
yes,
right, definitely. So one question that we've got, and we've got similar iterations even in the registration form that we circulated, is that how important is data, quantitative data in articles, particularly articles dealing with criminal law, which deal with crime statistics and so on. And with the recent sort of controversy in their accuracy being questioned, how should a person, either should they do their own pilot primary research or should they rely on those numbers, or is there a third source perhaps, or how much should they rely on quantitative versus qualitative data information?
So for academic purpose, if you are doing it, I have seen a lot of professors. I mean, Professor Rashmi, I think, would be an expert in this. She'll be in a better position to answer, but I'll still say with little knowledge that I have. Generally, research is of two kinds. So the research which you are doing for your dissertation and all, for that, what people prefer is they personally like to survey. For your PhD also, I have seen people are filling certain forms. They make a questionnaire. They take the views of the expert. They interview people. They personally go and visit. But when you are writing an article, you honestly would not have that kind of time to, personally go and visit and do a survey. Rather, it is good if you rely on a report or any kind of survey done by, for instance, a survey by Amnesty International. I did quote it in one of my cyber article on cyber terrorism, because they gave a very good statistic that how many cases are there, how women are being bullied online. So I could rely on all of that stats, and it does help to generate awareness. Because if I merely write without quoting the numbers, there is no credibility. But if I'm giving a source and it's a reliable source, then definitely people will take it seriously and they will think it's actually a big problem. For many of you who do not know about these cyberbullying and all, for example, once I give you the numbers, maybe you will take it seriously. If you read an article with the numbers, how many people have actually faced that kind of harassment, etc., how many people are being affected, and they ended up deleting their profiles, etc., major issues came up, then we actually see that, it's big in numbers. So I think statistics definitely help, not just in criminal matters. If in arbitrations also you are able to give a number to me, or in tax matters also you are able to give a number in IBC articles, I think that is very, very good. That shows you have worked hard and you are relying on a number. You're not just saying in the air. So it's good. It's always useful.
Right. Another question, again, a larger thematic question, because we've got a lot of them, is that when we're using a lot of judgment excerpts in blogs or articles, how does a person avoid plagiarism? Because it ends up that there is a case where there's a lot of substance that being picked up from primary sources or even secondary sources. So how do they avoid that? Is paraphrasing the right way to go? Is simply citing it the way to go, or perhaps another third way?
So when I've the major problem that I faced was when I was writing my books. Whenever I write a book, there is plagiarism because a lot of judgments are being cited. Sometimes I'm quoting it. So ultimately, the plagiarism report is what I'm scared of the most. At least in my articles, I've not seen most of them because are in the nature of a viewpoint. There's not any plagiarism. I don't think in my articles, which I've written as an expert for SCC online, I have not seen even 2-3% plagiarism because it's all just a thought process. Whatever I'm thinking, I'm writing in a candid manner. But yes, if I'm quoting judgments, it's unavoidable. You cannot do anything about plagiarism unless you copy paste from different articles. That's pretty embarrassing. That's not what one should do. But if you are taking some excerpts from judgment, something you are trying to communicate, I think it is perfectly fine. People are very lenient also. Some editors are not lenient. 20%, up to 20%, if your plagiarism is there, it's still okay. I mean, but if it's more than that, it's a major problem. Some even fine with 30%, but it depends from editor to editor. Some of the journals have strict guidelines, some are lenient about it. But apart from all of that, you personally should feel that you have put in honest efforts and you have not copy pasted or stolen anybody's work, because it's a lot of hard work. You don't have to really copy or it's not right ethically also. So as long as you are quoting judgments, if you are giving the credit, I don't think there is anything wrong in it.
Right. With this, I think we'll just take one more question, since I think we're almost going for 20 plus minutes for the quick Q&A session alone. So I think it makes sense for this to be the last question, since editing is the final process whenever one writes a manuscript. So a lot of students find it difficult to trim their articles. So as you said, that ideally a blog piece should be 2000 words at the very maximum. So if you could give them advice to keep it short and to the point and addressing the main core of the blog itself.
So that's a very important question you asked. I have been facing it for a long time. Whenever I start writing out of excitement, I write, and then I realize it's 3,500 words. And then I do not know what to delete, because when you have done something yourself, you don't feel like removing anything because it's a lot of hard work and you find everything relevant. So a good strategy can be that you can ask one of your professors, or you can request a colleague to read it and give comments what they are finding it relevant. But not everybody will have that kind of support. So for instance, I don't know, I don't want to bore anybody with my pieces. So I like to read it myself. But what I do is, when I have to trim it down, I just try to identify how I can reduce the sentences. Like I just highlighted, basic sentences which are running. Long sentences, you can just reduce them in a very short manner. Avoid unnecessary words, keep it as short as possible. And repetition, you will see at least 2-3 times. You are highlighting, emphasize. There's a difference between emphasizing and repeating. You can emphasize by merely putting something in one sentence in a proper manner by using powerful words. What I gave you an example of, by instead of saying words like the judge was very, very upset and angry, you can say judge was enraged. Then I gave you other examples. So 3-4 words you can just cut here only. Similarly, it will become more powerful. But apart from that, what you can do is you have to see what you are trying to achieve. Any information, okay, so every article must provide, highlight an issue or a case comment, or it has to provide a solution. People are looking for that solution. Irrelevant information is not required. From the introduction, you can reduce the introduction, make it just a 3-4 line introduction. Crisp. What happened? What did not happen? Many people are in the habit of writing, this is strictly denied. In drafting, you have seen every time the contents of para number so and so filed by the petitioner in his claim are strictly denied. Now, you don't have to strictly deny something. You can deny something. It's one and the same thing. Even if you say it's denied, it's denied. The court is not going to say, no, you didn't strictly deny it. It means you've admitted it. So all I'm saying is that sometimes we emphasize too much unnecessarily, which doesn't make sense. And sometimes we're just exaggerating and using long sentences as if it's a, and sometimes people forget what was the first part of the sentence and they reach by the end. So it loses the whole, I told you that, a person cannot focus for a long time. So identify what you're trying to achieve. For instance, in an article, sometimes I write very relevant information, but when I'm proofreading it, I realize that this is not going with the theme. I look at the title and it is unconnected. It is irrelevant. It may be extremely good information and very useful, but I will keep it for the other article. I will just remove it as it is. The whole heading will go. I will keep only what is apt and taking care of my title. And, because a person who's reading is expecting only that part. If you are writing an article on arbitrability, if you write something about seat and venue, no matter how good your research is, how great your content is, it's not required. And it's not going to help the user because the person is expecting about arbitrability and not seat and venue. So just remove the whole thing. Even if you have spent nights over it, just delete it. So that's my way of functioning.
Right. Thank you so much, sir. I'm sure all the attendees here and all the participants have gained a lot from your initial address and even the question answer session. On behalf of the entire team of VIPS Law Blog, we're really, really grateful that you took time out of your busy schedule on this Saturday afternoon and accepted our invitation to address all the attendees here. Now, it's my great pleasure to request Ravneet Sandhu ma'am, Assistant Professor, Vivekananda School of Law and Legal Studies, VIPS, to deliver the vote of thanks.
Thank you, Saharsh. Good evening, everyone. It gives me immense pleasure to propose the vote of thanks for today's event. At the outset, I would like to thank our speaker, Mr. Tariq Khan, who was kind enough to accept our invitation to deliver this lecture. And sir, we have gained a lot, and I'm sure all the participants have also gained a lot from all the tips, the tips that you have given to that would help us in our legal writing and research. And I would like to thank our management, Dr. S.C. Vats, the founder and chairman of VIPS, Mr. Suneet Vats, Vice Chairman VIPS, our patrons, Professor Dr. R. Venkata Rao, Chairperson VSLLS and VSES, Professor Dr. Subba Rao, Professor Emeritus, VSLLS, VIPS, and I would like to thank our Dean, Professor Dr. Rashmi Salpekar, who has always been very, very motivating and encouraging for all our events and for this particular blog since the very beginning. Our faculty members, Dr. Sushila Sharma, Ms. Samriti Verma, then our participants and all the attendees who registered for this particular event, and last but not the least, our student team, Saharsh, Namrita, Kashish and Divyam, who have been working for this particular event very hard. And it is not just for this event, but from the very inception of this blog, they have worked very hard. Thank you so much.
Thank you so much, ma'am. With the permission of Dean ma'am and Tariq sir, can we bring this session to a close?
Thank you so much, Mr.
Thank you.
Thank you.
Thank you, ma'am. Thank you for having me. And it was really my pleasure. Thank you, Saharsh. Thank you, Ravneet, ma'am, and all of you for taking out time. It was really my privilege, and I hope to see you all in person someday.
Sure. Thank you.
Right, participants, before you leave, we've put a feedback form in the chat box. Please do fill that